Yeah, but they're not doing their sports in the summer, are they?
They are, Judge. They're participating with their team and having sessions with their coaches.
Summer parenting time, tax credits, retroactive support. This isn't just about numbers, it's about access, accountability, and a 14-year-old caught in the middle. Dad wants week-on, week-off custody and financial adjustments. Mom says history tells another story. Subscribe for more dramatic breakdowns of real courtroom battles.
Parenting during the summer.
Yeah, I think we actually, Judge, and I apologize if I'm interrupting you. I think we agree on all the numbers. The only two issues that I think are at issue today for the court to decide are, one, whether he does get the tax adjustment. She's traditionally claimed the child every year. In fact, I believe this case was originally filed in Seward County in Liberal and was transferred here. The journal entry actually says that she will claim the child every year. He just didn't know better back then and didn't get the tax credit when it was originally figured. But he is requesting the tax credit, and I've sent the court that, and I apologize for the late notice on that. But the credit we're requesting is 151. That's just the number that Bradley spit out, and so we are requesting that. And then we are requesting summer parenting time. And if I can, I'd like to tell the court why.
Okay.
First of all, when this case was originally brought in Liberal, both parties.
So, hang on just a minute, Mr. Hawley. So
sure.
am I mistaken that you're asking for an adjustment for the summertime too?
Yes. And that's in my exhibit 4, I believe.
You are asking for both, an adjustment for tax and adjustment for summer if it's granted.
Yes, exactly.
Okay. Okay.
So
go ahead.
It's $113 for the summertime parenting calc. And I have that at exhibit 4, and then it's $151 for the tax credit. But both parties are living in Liberal. The case gets filed there. Sometime in 2016, 2017, mom moves with the child to El Dorado. And so obviously the original journal entry actually said 2 weeks on and 2 weeks off during the summer. So they originally agreed to that summer parenting time. I know that one of the reasons mom is objecting because she says, well, dad hasn't traditionally done that. And that is true. He is a travel nurse by trade. And so basically, I mean, he travels all over the nation, basically, or the Midwest anyway, to be doing this travel nurse job. He has remarried, and they have 2 children together. Ms. Locke and I have both agreed to use that multifamily adjustment. Like I said, our numbers are basically the same. I think it's only these 2 issues. So he's remarried. They have 2 small children. He actually moved. He was down in Southwest Kansas for a long time, and then sometime they lived in Fort Worth for a little while. But they moved. His family moved here to be closer. In August of 2023, he moved here to be closer to his daughter. And he hasn't worked into his contract. So basically, he's a contract worker. He signs a contract for a period of time, maybe 3 to 6 months, 3 months, 3-month time periods. And he's able to put whatever he wants in there. And so he can demand that he has this 6 days work, 8 days off. And that's the way he structured these. And he usually works at night because, they're starving for nurses. And so he can kind of basically make his own terms. And so he works 6 days on and 8 days off. And that's why we proposed a week to week in the summertime, because he'll be there 24 hours a day to be with the child, to take her to whatever she needs to do. He believed, I believe Ms. Locke put in her exhibits, there was an order that was filed on July 31st of last year, basically agreed order modifying parenting time. And he was pro se. He wasn't represented by an attorney at that time. And basically, there's some language that says that he gets every other weekend, Friday to Sunday. And then there's a sentence that says, father may exercise additional parenting time as agreed by the parties in advance. Again, he wasn't represented. He believed that he could still do his summer shared parenting time. And he had text messages from her saying that, yeah, you can see the child anytime you want, as long as it doesn't conflict with appointments that our family has or something like that, but you can have parenting time anytime you want. And then when we asked for the summer parenting time, she said no. And then we asked why, and I guess her reasoning was that that he traditionally hadn't done that. But all we're asking for is 113 a month and for the summer. And I know Ms. Locke's going to say, well, he's just wanting the summer parenting time so that he can get the adjustment. But first of all, it's only 113, and in the famous words of the Honorable Judge Hart, people used to make that argument about, well, he just wants shared custody because he can lower his child support. And Judge Hart said, well, if that's what gets him to spend more quality time with his kid, that's great. That's a wonderful policy decision. And so he just wants to spend some time with his kid. She's 14. As you said, she's going to be 15, and he doesn't have a lot of years left. And he just wants to be able to spend time with her in the summer. And he's luckily able to have a work schedule that accommodates that. And quite frankly, when he had this young family, his kids are 3 and 1.5. He was trying to make money, and so he was traveling out of state where he was getting some really lucrative contracts. But now he's able to work locally here, and he was able to do, especially during the summer, for that 3-month time period, to do the 6 days on, 8 days off, and it'll be available for the week. And so that's what we're requesting, the 151 adjustment for the tax, because he's never claimed the child ever in her life. And I think that's fair. And then the summer parenting time calculation. I mean, I think it's fair for him to have week to week parenting time. I don't think there's any allegations that he's.
I thought what we tried to do is if there was any time where we were making adjustments because of a change in parenting time, we tried to factor it into the whole year.
Yeah, see Exhibit 4, Judge. That's exactly what I did. Yeah, I annualized it. And so basically what I did on Exhibit 4 was I just took the guidelines say if you have more than 14, you can cut the child support in half. And so half of it was actually, that was based on the child support being 864, divided it by 2, which got to 432. I times that by 3 months, and that gave me 1,296. Divided that by 12, and that ended up being 108. But I think we'll have to figure out what the child support is first, and then we can figure. But that's the calculation that I used for.
Yeah, because you don't want the amounts changing.
No, and that's why I annualized it.
Okay. And so is he going to make a commitment to try to adjust his schedule every summer until she's 18, or?
Oh yes, no. The thing is, the good news is that he can tell these people when he signs the contract. He can say, this is what I demand. I demand 6 days on and 8 days off.
Okay.
And they'll do it for him. And yeah,
I just didn't know
do
if
it
it's
every
something
summer.
like, well, I figured it out for this summer, but it may or may not work next summer. I think that's kind of important too. So, okay.
Yeah, no, and he'll commit to that. And like I said before, there's kind of starving for nurses. So, he kind of can make the terms that he wants.
Okay. Ms. Locke?
Thank you, Your Honor. I have several points that I want to address. First of all, I don't want us to lose sight of any arrearage. And so while Mr. Hawley and I generally agree, like what the income numbers, insurance numbers will be, depending on what the court orders today, there will be some sort of arrearage for support that needs to be included at any worksheet. And so I wanted to make sure that was, or any income withholding.
Why is there arrearage?
We filed our motion to modify support in September, and our motion specifically asked that support be retroactive to the date of the month of the filing, which is consistent with the guidelines. So we are asking that the child support award be backdated to September 1st of 2025. And my client has historically had primary residency, but there has been no child support order. With the move of the case to Butler County, we did file a motion to modify for child support, which then resulted in this request for summer parenting time. But it would be consistent with the guidelines and consistent with the statute that child support would be retroactive to the date of filing or to the month of filing. Your Honor, this parent has not consistently exercised parenting time. And to say that he has adjusted his schedule to ensure quality time with his child is just simply untrue. And we can look to as recently as Christmas break to demonstrate that. Father's Christmas break time, according to the agreed modification of parenting time, was December 19th through to the 27th. Dad did not exercise parenting time until December 26th because of his work schedule, which required mom to trade her parenting time with him. So he ended up having parenting time the 26th through the 31st rather than his regularly scheduled parenting time. Now, I don't say that to say that mom isn't in agreement to modify the schedule, to make adjustments. Because she willingly traded her parenting time with him to accommodate his work schedule. But it is not the case that dad is adjusting his work schedule to meet the needs of the child or to meet the parenting plan. Mom is the one that's been flexible. And that's why the language is in the order that says that additional parenting time will be as agreed. Since the child went from 6th grade to 7th grade and started participating in sports more heavily in the summer, Dad has not regularly exercised parenting time. Our concern is that child support will be adjusted in order to accommodate a court-ordered summer schedule, and Dad will not exercise his time. Since we filed our motion to modify support, Dad has had several conversations with the minor child about why he is now working in Iowa, because he has to make more money, because he has to pay child support. These aren't appropriate conversations to be having with her, and it's not a good co-parent and parent-child relationship. I did ask Mr. Hawley if he would agree to allow the child to speak with you before the court made any orders modifying the summer schedule, and that was objected to. So I would be making an oral motion now that the court does not consider a modification to the summer schedule until the opportunity to speak with the 14-year-old. She is definitely of the age and maturity where she could provide valuable input on the parenting plan and the parenting schedule. I think there's concerns about missing sports, missing the summer opportunities, which we provided last year's summer sports schedule just for school athletics alone in our exhibit.
And there it is. The judge makes it clear. Dad will receive the tax credit once child support begins. Legally, that's significant. Tax allocation can shift thousands over time, but notice the balance. The credit only applies when support starts. Fair compromise or strategic win? What do you think?
I provided an email between me and Mr. Breeden to demonstrate that we believe that this request for additional summer parenting time is only to get a modification of child support, only to reduce the child support obligation and not, in fact, to increase his time with the child. Related to the parenting time adjustment itself, Judge, the child support guidelines provide the court a lot of discretion, specifically Section 4H, which is about parenting time adjustment, says, because the adjustment is prospective and assumes that the parenting time will occur, the court may consider the historical exercise or historical non-exercise of parenting time in deciding whether or not to grant the adjustment. Historically, Mr. Breeden has not exercised his summer parenting time. Historically, he has not exercised a lot of time with the child, resulting in mom spending significantly more time with Lily. Additionally, Your Honor, Mr. Hawley's statement regarding the extended parenting time adjustment is inconsistent with the guidelines. It's only if there is 14 or more consecutive days that there would be a automatic 50% reduction. The contemplated schedule in the request in the motion is not for 14 consecutive days, but rather a week on, week off schedule, which would not allow for the automatic 50% reduction, but rather we would be looking at a parenting time reduction, which is up to 30% adjustment. So, Judge, ultimately, we are asking that the court assess arrears once the child support is determined, to deny the request for summer parenting time. If the court is going to take the summer parenting time under advisement, we would ask that the court speak with the minor child in advance of making a decision on summer parenting time and determine whether that extended time is in her best interest. And for an order of support today, retroactive to September 1st of 2025.
What's your position on him getting a credit for tax?
Judge, my client believed that the current and the most recent order had them alternating the tax deduction. It doesn't care either way, whether there's an adjustment for tax and she claims her every year, or if they begin alternating the deduction, she doesn't have a preference.
Okay. But you agree you should get one or the other?
Correct. Yes.
Okay.
We would ask that that not be included in the 2025 because there was he wasn't paying support. He didn't pay support for all of 2025, despite the fact that the child lived and resided primarily with my client.
Okay. This athletic schedule, well, first of all, is she a freshman going to be a sophomore, or is she an 8th grader going to be a freshman?
She is a freshman going to be a sophomore, Judge. And she participates in basketball, volleyball, and softball. Just basketball and volleyball. Sorry.
Is this just the weightlifting? Yeah, it's just the strength training and they break them down.
So, Judge, sorry, I apologize for interrupting. The first row there is for strength and conditioning, which all of the kids are encouraged to participate in. And then there's individual breakouts later in the day for volleyball and basketball and soccer if she wants to play soccer instead.
Yeah, but they're not doing their sports in the summer, are they?
They are, Judge. They're participating with their team and having sessions with their coaches.
Oh, I thought that was a violation of the high school.
There are certain moratorium periods where the coaches cannot have contact with the athletes, and those are reflected at the bottom in those hexagon square things.
Oh, okay. Well, and strength training used to be elective for the kids during the summer, but I would assume if you want to play these sports, you better participate over the summer.
As a coach, I would say that that's accurate. It's optional, but strongly encouraged.
Well, there's no issue with him getting the child during his week if he's not working to these things.
Historically, Judge, during Dad's time, when he did have the opportunity to exercise the time, the child ended up staying with Mom because it was easier and more convenient for Dad. And so while we agree that there would be no issue if he did have no work, the historical pattern, which the court can consider in making a modification, is that Mom ends up spending the time with her anyway because it's more convenient for Dad if she just stays in El Dorado rather than driving back and forth to Andover.
Does Mom have other children in her household or stepchildren?
Yeah, two additional children, Judge.
Are they hers?
Yes.
And what are their ages?
2 and 3, 2 and 4. 2 and 4.
Okay. So they're kind of similar in both households with toddlers, so to speak. Okay.
Judge, could I just briefly respond?
Let me ask one more question.
Sure, I'm sorry.
That's okay. Ms. Locke, have you spoken to Lily yourself? Can you proffer what you believe she might say?
Your Honor, I have not spoken with her directly. I didn't feel like that was appropriate. I could proffer what I believe she would say, but again, I think that our preference would be that the court speaks with her directly so that she doesn't feel like she's being put on one side or the other.
Okay. Mr. Hawley?
Well, I guess I'll just start there. That was the reason why my client objected. He did not think it was fair for the child to be put in a position where the child was, choosing one parent over another parent, and didn't feel like she should be involved in this litigation any more than she has to at all. My client, it is true that my client hasn't exercised all of his parenting time. Again, he was taking these positions out of state where he was making a lot of money in order to try to help his new family out. He's now again moved, and he does live in Andover. So he's now available to be able to take the child. And I think it's a wonderful opportunity for him to be able to spend some time with the child. And they did switch over Christmas. He did have to work during that parenting time, and they were able to switch weeks. And he said they've done great about switching weeks all the time. Great about switching back and forth whenever either one of them had a conflict. And with regards to the start date, I would say that there was an order. It's a weird order in the original one that they split expenses. So he was paying for half of the sports and all the other stuff too, and has been paying for all of that up until they filed this motion. And so I think that he should get the tax credit beginning when the child support starts. And we would ask the child support start in October. They didn't file this until September 30th. And I believe the statute doesn't say the month that it's filed. I believe the statute says it's the month after it's filed. But even if it's the month that it's filed, I mean, she filed it on September 30th. So, I mean, it should start October 1st. But that's my client's position. He's available. He knows about this summer athletic schedule. He's happy to take her to all of these. And that'd be a wonderful time for them to be able to spend more time together.
Now this is the tension point. Mom cites the guidelines, arguing historical non-exercise of parenting time should block the adjustment. That's powerful. Courts can deny prospective credits based on past behavior. Dad says he's changed. The question becomes credibility. Is this genuine commitment or financial motivation dressed as parenting?
Thank you.
All right. Well, I mean, obviously I'm going to give him the tax credit, and it's effective from when the child support is set to commence. I'm going to try the week on, week off and see how this summer goes. And Ms. Locke, your client needs to keep track. And if he misses any weeks, he's going to forfeit the ability to do it again. And I might assess some attorney's fees or something against him if you've got to come back to court and modify that because he didn't exercise it. So, but I think this is an important time for both parents to have a good foundation with her as she progresses into teenage years and more independent. She'll eventually be driving. She might be working. She might be doing sports. I think there's probably going to be less contact one direction or the other because kids from their junior and senior year tend to like to stay planted near their friends or in one place. I think that's going to be a natural transgression, but I think it's important for her to have trust and communication and a good framework for her to help her be able to make decisions as she becomes closer to being an adult. So I think I'm not ordering it every year. I'm ordering it this year, and then I will review it. But but I'm only going to do the 30% credit, not the 50. And the tax credit, and of course, annualize it like you did. And I'm going to make it, effective October 1. And so you also need to annualize the arrearage, and add that in to figure out how, I don't know if he wants to pay a lump sum or how you want to do it, but he's got a few months now, to 3 months, October, November, December, January, actually 4 months. I'm actually going to make it everything effective as of November 1. So he's 3 months behind, and so you need to factor that in to pay that arrearage off. Okay. I think that's it then.
Judge, are you awarding the parenting time adjustment for the 2025 child support worksheet, or only the January 1 worksheet moving forward? There are 2 worksheets because there was an adjustment to insurance.
Okay. Well, it's going to be annualized for a year, so I would say that should be January 1 that one starts. So you are correct.
I think the guidelines go up to 35%, don't they? Not 30%. I thought the adjustment was.
I'd have to look, but I just took Ms. Locke's word for it.
It's the parenting time adjustment is either 10, 20, or 30%.
Okay, I apologize. It used to be 35 at one point, I think. I think that's before they did the shared thing. I'm too old. Okay, 30%.
Yeah. Okay. If you find out something different, let me know, but that's what
I want to draft the order, Judge.
I don't know who has, I mean, you've both done some work on it.
I'm happy to take a crack at it if you want me to.
Yeah, why don't you do it? It's kind of your motion. Yes, please. You do it. And then she can you can't really do an IWO since he contracts. So, but this will be paid through KPC, right?
Yes.
Okay.
So November 1st start date, 30% for the summer, starts January 1, annualize the summer. Okay, I think I've got everything.
And then you guys will either keep it going by agreement, or you'll get a court date December of this year at the end of the year for me to review it and decide about the following summer.
Judge, what if I put some language in there, and I would appreciate Ms. Locke's opinion on this also, but I just had this kind of similar issue come up in another case, and basically the language that we used is that father gets the summer parenting time. Either party may file a motion after the summer to modify that or something like that, and that way you don't take up time on your calendar or anything for a review date.
That's fine too. That makes it more formal than me just giving a review or saying, hey, call up and ask for a review.
Yeah, and then it's also in the order that the court contemplated a review if it doesn't go well.
Do you guys have to pay a fee every time you file a motion?
A motion to modify.
Yeah.
So there'd be a fee. Huh?
Post decree, yeah, you do have to file. You have to pay.
Is that like $150 or what?
Something like that. Yeah.
I'm just going to give them a review date, and then it stays in effect unless there's a motion at some point, at any point. But I don't want them to have to pay a new. I mean, unless you guys don't want to stay on the case as counsel of record and want to withdraw like you often do, then I won't give a date.
Yeah, I would prefer that language that just,
Okay.
if it doesn't
All
go
right.
well. And then, like you said, Judge, if it doesn't go well, I mean, you can assess the filing fee against my client.
Okay.
Mom files the case.
All right. Fair enough.
Your Honor, I would like the order to include that our request for the child to be interviewed is being denied.
Okay. And I may next year interview the child, but I'm not going to do it this year. I don't do it very often, frankly. And when I do, it's usually 16 or 17-year-old kids. So, I want to try it. I think this is probably going to be, well, yeah, freshman to sophomore year, summer's pretty critical time for kids. So, yes, I mean, I guess it can be part of so, Mr. Hawley, you're going to do the order and the worksheets.
Yes, y'all
Okay.
do the whole thing.
All right. Okay. All right. Fair enough. Anything further?
No, Your Honor.
All right. We are adjourned. Thank you.
The judge splits the difference, week on, week off for this summer only, but just a 30% adjustment, not 50%. It's a trial run with consequences if dad misses time. Retroactive support starts November 1st. Structured, conditional, cautious. Like, comment, and subscribe for more shocking courtroom stories.